So, good morning to everybody. Good morning, to Germany, China, and wherever. My name is Jochen Schultz, and welcome to the breakfast seminar of the CNBW together with CMS on a topic on what is new in Chinese law, topics which may concern you in 2023. So you are correct when you register to this event. I'm from the CNBW, which is the China Network of Baden-Württemberg. I'm the general manager, and I would like to give you a very quick introduction. So we are an association. We are an association under German law, and we are a private and independent association, which also means non-profit. And our idea is to foster the relationship and the cooperation between Baden-Württemberg and China. Baden-Württemberg, for those who don't know, is a region, a very important region in the southwest of Germany. But we are actually looking into the collaboration between Germany and China. As you can see, we understand ourselves as a moderator for exchanging know-how, context, and other knowledge. And we are doing this also together with our members and partners like CMS. So thank you very much already. And the know-how and knowledge transfer is also by events and webinars like today. Baden-Württemberg is also partner province of Jiangsu Liaoning province. So to go to the next slide, please. Here you see a quick introduction to who's in charge of. I'm on the bottom left, or actually I'm twice on the slides, and I'm also one of your contact person here. You will get the slides later, so just that you see already some faces. And when you go to the next slide, please, then you also see that we are in China. So when you have any questions, so you can contact one of those. And on the next slide, you also get an idea of the experts who are working together with us, experts from different organizations in different regions. So our idea is to bring the best know-how, contacts, etc., into the network together with the network. And when you go to the next slide, you see examples. The members we'll see later. But why I'm sharing this with you is we doing knowledge transfer, network exchange, etc., with events like today and content we are having, but also with special working groups. And as you can see on the very right, we also have one for legal and tax. As this is a legal topic today, I thought I'm going to share this with you. When you're interested, and please go to the next slides, then please contact us. Here you can see an example of our members. You can see also CMS. And when you go to the next slide, please, and this is the final slide from my side now, there are quite a few possibilities to follow us. On the right, the QR code is a WeChat account. You can also follow us. So I hope you get a quick idea on what we do, who we are, and we will share this presentation together with the other presentations later. Okay, then thank you very much from the CNBW side. Before starting with the content, before starting with the presentation, I would first of all like to thank CMS. So CMS, one of our member companies, like making it possible to have this interesting and very important webinar on a very important topic today. To give you an idea who CMS is one of the top 10 global law firms. They have more than 5,000 professionals, legal and tax advisors in more than 40 countries, in a lot of offices around the world. CMS advises clients in both global and local matters and provide pragmatic and commercial advice. For those who are in Germany, you might know them by CMS Hasche-Siegler. And they have 8 offices and a very large one in Stuttgart. So unfortunately, we are not going to meet there today, but you're invited to be there next time. It's I heard a really nice new office in China, and all of those 3 speakers today are from the Shanghai office. They have been there for several decades and has offices in, Shanghai, Beijing, and Hong Kong, and is also mentioned and nominated as one of the top international law firms in China. They advise overseas companies doing business in China, but also the other way around, Chinese companies on outbound investments. They addressing different topics. I believe the most interesting topics in the legal area, and we will learn more about some of those topics today. Which brings me to the experts you're seeing already, and you're hearing more later. The way we're doing this, we will have, when I stopped my introduction, we will have the presentation first, and then we will have a Q&A time slot. So in total, we have 60 minutes. So we stop by around 10 a.m. German time, which is 5 p.m. in China. And so you're invited to address your questions already during the presentations in the chat, and also after. We will bring in the questions into the discussion then after the presentation. So the first one who's starting with the presentation today is Ms. Dr. Ulrike Glueck. Ms. Glueck is German, and she's holding also a German law degree. She's also the managing partner and head of corporate practice area group of TMC sector group of CMS China. She's usually based in Shanghai, and having said that, she's holding a German law degree, and she also practiced in Germany for several years. She has been working on-site in China since 1998, so more than 25 years experience in China-related work, and she has already advised a large number of companies in various industry sectors. She's leading a team in China, and she in person, also the team and the office, won a lot of awards. I think I won't name them, but I think it's quite impressive. So good work, and she will share her experiences then later, together with two of her colleagues from her team. The first I would like to introduce here is Jeanette Yu. She is a partner and head of employment and pensions of CMS in China. She's also more than 20 years experience in providing legal advice for international companies on Chinese labor law issues and compliance management in China. And she's also has been recognized as a leading individual in employment by chambers and partners in this year. And finally, Ms. Tang will do a presentation later as well. She's a senior associate at CMS in the Shanghai office, and her topics are like intellectual property, information technology, etc. And she also already supported a lot of European companies in China. So this was a quick introduction. When you want to learn more about the experts here, you're also invited to contact them after the event. You will, with the presentation you can have afterwards, you will also get the contact details. So that's all from my side at the moment, and I think we should start and get into the content, and I hand over to Dr. Glueck.
Thank you very much, Mr. Schultz, for the introduction, and good morning or good afternoon to everybody. I'm very pleased to welcome you to our webinar, What is New in Chinese Law? Topics which may concern you in 2023. Already for considerable time in China, companies constantly have to deal with changes in regulations and with new laws. And this will, of course, also continue in 2023. Amendments of existing legislation and new laws will come in various areas, For example, there are plans to amend the PRC insolvency law, China's competition law regime will be further strengthened, and the corporate social credit system will be further streamlined. There will be changes in IP laws and in data protection, in labor laws and in tax law. If you would like to have a full update, please feel free to access our newsletter on this topic on our website. For this seminar, due to time constraints, we had to focus on a number of topics and selected the following ones. In the area of corporate law, I will brief you on the new corporate structure for joint ventures and on potential amendments to the PRC Company Law. Our labor law specialist, Jeanette Yu, will brief you on new developments in Chinese labor and social security law. And last but not least, our IP and data protection specialist, Panpan Tang, will share with you updates in Chinese IP law and cross-border data transfer. So first to the corporate law topics. Next slide, please. Next slide. Thank you. For those of you who are active in China, and I guess most of the attendants are, know that for more than 2 decades, foreign invested enterprises were subject to a different set of laws than domestic enterprises. There were 2 types of joint ventures, equity joint ventures and cooperative joint ventures. Equity joint ventures were governed by the equity joint venture law and implementing rules. Cooperative joint ventures were governed by a separate set of laws, and wholly foreign-owned enterprises were governed by the WFI law and its implementing rules. In addition, of course, for all the PRC company law applied, but the special above laws, which I just mentioned, were lex specialis, and this had an impact especially on the corporate structure of joint ventures. Now already in 2020, the special laws for foreign invested enterprises were abolished. However, there is a grace period until end of 2024 for foreign invested enterprises to adapt to the new legal requirements and to implement the relevant corporate changes. In practice, this actually only concerns joint ventures. WFIs are not affected because their corporate structure already for many years had to follow the PRC company law. Next slide, please. Now, if you have what I call old joint ventures, so joint ventures which were established already some time ago, what must be changed? In the past, for old joint ventures, the highest authority was the board of directors. Latest starting from January 1st, 2025, it must be the shareholders meeting. In the board structure in joint ventures, the shareholders do not have a direct say, but only indirectly through the directors appointed by them. So far in joint ventures, there was no shareholders meeting. All decisions were passed by the board, and the board was the most important authority. After the change, it will be the shareholders meeting. Under the old law, for board meetings and decisions, there is a mandatory quorum of 2/3 of the directors, which means that if not at least 2/3 of the directors show up, then no decision can be passed. It's quite a good opportunity to block. Under the new law, there will be no quorum unless the parties expressly agree on a quorum in the shareholders meeting or in the articles of association. Then, very important item under the old law, major matters such as changes of the articles of association, increase or reduction of registered capital, mergers, and also dissolution, so liquidation of the company, required a unanimous approval by all directors. Again, that means that such decisions could be easily blocked by the minority shareholders. After change of the structure, the statutory law provides that all these important issues like capital increase, capital reduction, change of the articles of association, which also means in the articles of association, for example, if you want to change the business scope, etc., According to statutory law, this will only require 2/3 majority in the shareholders' meeting. Of course, it is still possible to agree in the shareholders' agreement and in the Articles of Association that a higher majority threshold shall apply. So the parties, the shareholders, can still agree that it's still unanimous decision. But of course, the majority shareholders, they should strive to stick to the 2/3 majority voting. In joint ventures, under the old laws, only the chairman of the board of directors could serve as legal representative. The new law is more flexible. Same as already possible in wholly foreign-owned enterprises, it is possible to get rid of the board completely and to only have one single executive director instead of a board, who can then serve as legal representative. It is also possible to have instead the general manager registered as legal representative. So far, transfer of shares to third parties in a joint venture required unanimous approval by all other shareholders. So again, they could block. Under the new structure, only approval by more than 50% of the other shareholders is needed. Of course, I already mentioned it, for all the above changes, the joint venture contract or shareholders agreement, whatever you call it, and the Articles of Association must be changed. This requires cooperation and consent of all shareholders, which means also the Chinese partners, and in many cases will probably be time consuming. Thus, if you have joint ventures, old joint ventures, so to say, and did not yet adjust their corporate structure, it is advisable not to wait until the last day, so to say, of 2024, but to really start early, because the negotiations may take some time. So far, all foreign invested enterprises, apart from a registered capital, also have a so-called total amount of investment. This is a theoretical amount which does not have to be paid in and also does not show up on the balance sheet. But it has relevance for the so-called foreign debt quota of a foreign invested enterprise. The foreign debt quota is important for taking out loans from abroad, because loans from abroad are limited by their amount to this foreign debt quota. And the difference between there are different methods of calculating a foreign debt quota. One of them is the difference between the total amount of investment and the registered capital. And it is unclear whether this concept of total amount of investment will still stay or will be abolished. So far, it hasn't been abolished, so that's to see in the future. Next slide, please. In 2023, we will also most probably get an update of the PRC Company Law. The draft of the amendment has already been released end of 2021 and was open for public comments until the end of January last year. Under normal circumstances, it should have been already passed last year, but it was obviously delayed because of the pandemic. So the update is very likely to be enacted in 2023. The exact content of the actually enacted law might differ from the draft, which was published end of 2021. Next slide, please. Now, if the current draft or the draft published in 2021 would be enacted, this would bring along some important changes, and I want to introduce to you the most important ones. First, the draft promotes electronic functions to simplify administrative formalities. An example is the introduction of an electronic business license in addition to the paper business license. Actually, in some regions of China, for example, in Shanghai and around Shanghai, this has already been implemented in the past years. Another important change would be publicity. There is an electronic company register, and which everybody can access. And this electronic company register currently provides a basic overview on companies, like who are the shareholders, what is the registered capital, usually has it been paid in or not, who are the directors and other company organs, were there any changes to the registered capital, to the registered business license, share transfers, etc. So everybody can see the basics and the outline from the electronic company register. It is currently very difficult to also to get more information, or in order to get more information, you need to access the actual physical company register. And that has become more difficult over the years. Like, for example, a couple of years ago, by engaging a local agent, it was possible to get copies of the Articles of Association and other documents registered in the company register. Of course, this was always a bit questionable, because basically you did not, in order to access it, you did not have to prove that you have a special interest. And in recent years, the company registers, they are located at the market supervision authorities, have become more cautious and careful. So currently, mostly, if a third party wants to get access to the physical company register, they need to show a court judgment, which basically makes it impossible impossible to get these documents. In the past, this was, for example, used to check suppliers, or also to check competitors, etc., the detailed situation. The draft now provides that also articles of association will be published. Another change refers to capital contributions. As I'm sure you all know, capital contributions can be made in cash or in kind. And so far, capital contributions in kind are limited to certain assets. For example, equipment, shares, land use rights and buildings, and technology. Accounts receivables, so open claims arising from supplies or services, etc., cannot be contributed as capital contribution. The draft now also allows contribution in a form of stock rights and creditors' rights. Personally, I find contributions of accounts receivable a bit questionable, because it is not sure whether these accounts receivable can actually be realized. So what happens if in the end they cannot be realized? Then does part of the capital contribution switch back to unpaid? And will the shareholders have to make up this part? So lots of questions actually arise from this. Currently, transfer of shares in limited liability companies to third parties require consent of the other shareholders. This requirement, at least in the draft, is also cancelled. Then board members, currently a board of directors of a limited liability company must consist of between 3 to 13 members. And this upper limit may also be cancelled. Another important change suggested is to have employee representatives in the board of directors of limited liability companies which have more than 300 employees. Now, this would really be a big change and impact. Companies also have a supervisor or supervisory board. As maybe not all of you know, in case a company has a supervisory board, which consists of 3 members, one of them must be an employee representative already now. But it is very easy to circumvent this, because companies of a smaller scale or with a small number of shareholders, they do not have to have a supervisory board, but they can choose to instead only have 1 or 2 supervisors. And by doing this, which most of the companies do, they can avoid to have an employee representative in the supervisory board. Also, supervisory boards in non-listed companies are, to be frank, not that important. I always used to call them paper tigers, more or less, because they should, of course, review the financials, and they can remind managers to follow the articles of association, etc. But in practice, their role is very minor. So, but of course, board is different, because in the board, the major operational issues, the planning, etc., are discussed and decided. So if there would be employee representatives, this would really be a change of the entire picture. And I guess that if implemented, quite a number of shareholders would not be very enthusiastic about this. This is also the reason why part of the lobbying done by, for example, foreign chambers, EU chambers, etc., was also focusing on this item. This was an overview on important potential changes in the PRC company law. As I said, whether and to which extent they will actually be included in the actually enacted revision of the PRC company law still remains to be seen. Next slide, please. So this was my short brief on some changes and to be expected changes in the corporate law area. I am happy to answer questions at the end of this webinar, and now hand over to my colleague Jeanette Yu, who will inform you about some changes in employment law. Jeanette?
Yes, here. I'm here. Okay.
Yeah.
Yeah, thank you, Ulrike. Good morning and good afternoon, everybody. Now I would like to discuss with you on some employment topics. You may know that in China, starting from the beginning of this year, the PRC law on protection of rights and interests of women was just amended and it became effective. The amended law raised specific legal requirements on employers in protection of the women in the workplace. Regarding the elimination of gender discrimination against women, in the recruitment section, employers are expressly prohibited from taking discrimination towards female candidates, such as, for example, except for law provides otherwise, employers should not only hire males or specify that males are preferred to the position, or inquire about female candidates' marriage and childbirth status, or ask a female candidate to do pregnancy test in onboard physical examination, or even set restrictions on the marriage or childbirth intention or status as a condition for employment. During the employment, the employers should adhere to the principle of equality between male and female employees on salary payment, or in the process of making promotion, evaluating and recognizing professional titles, or provide training opportunities. In addition to the statutory obligation of the employer provided by law in the past, such as female employees enjoy special labor and dismissal protection during pregnancy, maternity, and nursing period, the amended law imposes new obligations on the employers. For example, employers must include special protection clauses for female employees in their employment contracts, or the employers should regularly arrange specific health examinations for female employees. During the pregnancy, maternity, or nursing period, in addition to salary, employers should not reduce female employees' welfare and benefits as well. Further, The amended law requires employers to adopt measures to prevent sexual harassment in the workplace. This is the first time that the law expressly requires the employer to do so at the national level. These measures can be divided into two parts. One part is to prevent the occurrence of sexual harassment in the workplace. They include formulating relevant rules and regulations, specifying responsible organizations or people in charge, carrying out relevant education or training program in this regard, adopting necessary safety and security measures, setting up complaint hotlines, or establishing investigation procedures. The other part of the measure is to be taken when dealing with the harassment cases. That is, when receiving any complaints, the employer should handle the dispute in a timely manner. During the investigation process, protect the privacy and the personal information of the parties concerned, support female victims in safeguarding their rights, and providing psychological counseling to the female victims when necessary. According to the amended law, gender equality in the workplace will be under labor security supervision. That means that the female employees can directly raise complaint for discrimination at the competent labor administrative authority. If the complaint is true, the authority is entitled to ask the employer to make rectification. If the employer refuses to rectify or the circumstances are serious, the authority can impose a penalty of RMB 10,000 RMB to 50,000 RMB on the employee. So in order to comply with this new legal requirement, companies in China may wish to revisit their employment documents and HR policies, review their current employment process and the labor protection practice, and make necessary adjustment if necessary. Then my next topic is about the development of China's social insurance mechanism. Please, next slide. Thank you. The measures for administrative supervision of social insurance funds issued by the Chinese Ministry of Human Resources and Social Security on 18 March 2022 is one of the signs that the Chinese government takes substantial action in strengthening the implementation of social insurance policies. As a basic rule in China, an employer is obliged to provide social insurance, including pension, medical insurance, unemployment insurance, work-related insurance, and maternity insurance for all its employees, including both Chinese and foreigner, at its registered location according to the statutory standard provided by law. But in the past, some employers, they didn't strictly comply with the social insurance policies in their daily operations. For example, some of them, they didn't provide social insurance for their employees, especially foreign employees. Some of them paid social insurance contributions for their employees lower than statutory standards. Some of them did not provide social insurance for their employees in their own names at their registered locations, but at other locations in the name of HR agencies. In recent years, the Chinese government took measures in developing the social insurance mechanism such as the following. First, changing the authority levying social insurance fees to the competent tax bureaus, so that whether an employer duly and fully pays social insurance contributions for the employees can be easily found out from the database of the tax bureau. Second, strengthening the supervision on payment of social insurance contributions. The competent labor administrative authority becomes more active to support employees to raise complaints against the employer if their social insurance contributions were not fully paid. Third, regularizing HR agencies' provision of social insurance service. For example, starting from last year, many Chinese companies were notified that they will no longer be able to provide their employees with social insurance at the places other than the company's registered locations through HR agencies. If a company fails to provide social insurance for the employees in compliance with the law, the company may be subject to administrative liabilities, such as being ordered to make up outstanding payments, being imposed with late payment fees or penalties, or the company can be claimed by their employees for paying compensation if the employees fail to enjoy social insurance benefits due to the faults of the company. Therefore, in 2023, companies doing business in China may wish to ensure being fully compliant with the statutory Chinese social insurance policies. Next slide, please. Thank you. My next topic is not new, but may concern in 2023. That is managing labor costs in times of difficulties. This year, companies may face financial pressures or operational difficulties, and might need to look for possibility to control and reduce labor costs by restructuring business, lay off employees, or reduce employees' salaries or benefits. When deciding to take measures, companies should pay attention to and follow the legal provisions under PRC labor law. Otherwise, a labor dispute might occur. Here we provide you some basic rules under PRC labor law which may be useful for you. First, in China, without express consent of employee in writing, the employer should not reduce the salary of the employee except for statutory circumstance. Such statutory circumstance can be, for example, if the employee is changed to another work position because he's proved to be incompetent or due to illness, and the salary standard of the new work position is lower according to the company's remuneration policy. But just be reminded, in China, as long as the salary is not reduced, employee's work position can be changed without his consent, as long as such change is reasonable and due to operational needs. This rule will be useful in case of restructuring of business. Then, whether the benefits can be reduced or not is subject to how they are agreed. If the benefits are provided in the individual contract of the employee, to reduce the benefits, a consent of the individual employee is needed. If the benefits are provided by company policies, such as in employment handbook, except the Employment Handbook provides that the employer can change or cancel these benefits at its discretion. Otherwise, the employer should change the employee's handbook by conducting a collective consultation with employees. But no consent is needed from each individual employee. Please note that in China, unilateral termination of employment contract by employer is difficult, and the employer has to be very cautious. Under PRC law, employment contract can only be unilaterally terminated by the employer if one of statutory termination reason is fulfilled. Such statutory termination reasons are very limited. They include employees' serious breach of company rules, or neglecting duties, or practicing grafts, causing serious damage to the company. In such a case, the company can conduct an immediate dismissal without any compensation on the employee. Or the termination reason can be the illness of the employee, or employee's incompetence for work, or due to change of objective circumstance. In such situation, the company can conduct a termination on the employee with a prior notice period after following statutory procedures. In practice, it is very difficult for the employer to have sufficient evidence to prove the establishment of a termination reason, especially for incompetence of the employee or the change of objective circumstance. Therefore, in case of unilateral termination, the employer may have the risk of being required to reinstate the employment relationship with the employee, or paying compensation for unjustified termination if the employee goes to labor arbitration. In China, mass layoff is possible if the company suffers in economic difficulties and wants to lay off more than 20 employees, or 10% of all staff. But the company should consult all employees about the mass layoff plan in advance, and then have such plan filed with the competent labor administrative authority. In practice, it is difficult to implement because the authority does not support the mass layoff at all. Therefore, in practice, most termination cases are handled by reaching a mutual termination agreement with employees. According to the law, except for the termination is caused due to the fault of the employee or the resignation of the employee. In most of cases, employer must pay severance payment to the employee for the termination of contract. The statutory severance payments are calculated based on the working period of the employee at the company at the rate of 1 monthly salary for each 4 years of employment, but with a cap of 3 times of average monthly salary of employees at the location. For example, in Shanghai, such cap is around euro 4,500 per month. If the employment contract is terminated by mutual agreement, to reach agreement, the employer usually has to offer more severance payments than statutory ones, and the amounts of severance payment are subject to negotiation of the parties, depending on who has more bargaining power. Therefore, if the company decides to conduct dismissal on employees before taking action, company may wish to evaluate the situation, consider termination strategy and action plan for that, This will help the company to terminate the employment contract with the employee in the most efficient and economic way and reduce the legal risks of the company. Now that's the end of my part. I will hand over to Panpan. She will give her updates on IP and data protection topics. Thank you.
Thank you, Jeanette. Good morning and good afternoon, everyone. Next, I'd like to talk to you about some updates about China's trademark law and data protection law. I want to begin with the potential updates to the PRC Trademark Law, and then I will move on to the legislative developments in cross-border transfer. To get started, let's take a look at the timeline of the development of the trademark law in China. China's first trademark law was enacted in 1983 and has undergone 4 revisions since then. Well, recently, on January the 13th this year, the 5th revision was just published, and it is still in the stage opening for public comments. This revision has expanded from the original 73 articles in 8 capitals to 101 articles in 10 chapters, and it is a relatively large-scale revision. So next, I'd like to introduce to you 5 major amendments, which I think may lead to some changes that companies need to take to their daily trademark portfolio management. Next page, please. The first change is that this provision provides more provisions prohibiting malicious, or we say bad faith trademark registration. This revision clearly lists some circumstances that constitute bad faith application for trademark registration, among which the situation of applying for a large number of trademarks without a purpose of use deserves your attention. In the past, many large companies may have registered trademarks in 4 classes for defense purpose, but in fact, the company will still only use their main brands on the products or services they actually operate. So after the change, companies may need to focus on the needs of actual production and operation in the future, and reduce the number and the frequency of trademark applications under the single same entity. And the next change is that this revision prohibits duplicate applications, which means the same applicant shall register only one identical trademark on the same goods or services. In practice, many companies may file repetitive applications in order to prevent the trademark from being cancelled because it is not used for 3 consecutive years. So they will apply for the same trademark repeatedly every 3 years. So after the change, companies may need to adjust the overall strategy of trademark applications. For the trademarks that have already been approved for registration, companies should make plans for the use in actual business activities. And when applying for a new trademark, you need to consider more carefully the goods covered by the trademark application in order to meet your actual needs. The next change is that this revision strengthens the obligation of companies to actually use the trademarks. Currently, China adopts the first to register principle in trademark registration. Under this principle, the exclusive right to use a trademark belongs to the company or person that first applied for registration, and who uses a brand first is not considered. The corresponding reality is a large number of registered trademarks are not used, and the relevant resources are wasted. Now, this revision requires applicants to at least undertake to use the applied trademarks when they file a new application. In addition, this revision also requires companies to declare their use of trademarks every 5 years. Meanwhile, the trademark authorities will do random inspection of companies' declaration of trademark use. If the declaration is found to be untrue after the random inspection, the registered trademarks may be cancelled. So in view of this change, companies shall make plan to continuously use the registered trademarks, establish a special database, or formulate an internal guidance, and require relevant departments to retain evidences of use at any time. And it is also necessary to clean up trademarks that are no longer in use in a timely manner. The next change is that this revision has improved examination procedures. The previous trademark examination process is like that. In 6 to 9 months after an application is submitted, the authority, that is the China National Intellectual Property Administration, will publish the trademark application for a 3-month opposition period. And during this period, any third party who opposes the registration can file an opposition. If no opposition is raised after the expiry of the 3-month opposition period, the registration will be approved. Now, in this revision, the 3-month opposition period has been shortened to 2 months. But if any third party raises an opposition in the 3-month opposition period, and if the trademark applicant loses the case, the applicant can request the CNIPA, the authority, to review the decision. This process usually takes another 1 year. So in this new revision, this procedure has been cancelled. If the applicant is not satisfied, it has to file a lawsuit directly with the People's Court. So these changes can help improve the trademark granting efficiency. And in view of this change, we recommend that companies pay particular attention to this shortening of the opposition period. And this will mainly require trademark management department to make faster decision to file opposition against the similar trademarks identified during your regular monitoring. The last change I'm going to talk about is that this revision provides for more measures to crack down on bad faith registration. For instance, punitive measures against the bad faith trademark applications are introduced for the first time. This revision provides that for bad faith applicants, the relevant right holder may file a lawsuit at the People's Court to claim civil damages. And in addition, as administrative penalties can be imposed on bad faith applicants, the upper limit of administrative penalties has been increased to 250,000 RMB. And this change brings more means for companies to crack down on bad faith applicants, and companies can, in parallel of trademark opposition or invalidation procedure, consider filing administrative complaints or civil lawsuits against the bad faith applicants, in order to increase the illegal costs of bad faith applicants. Okay, that's all for the trademark topic. And now I'd like to move on to the second part of my presentation about the data protection. Next slide, please. Okay, to start with this topic, let me first give you some background information about the data protection law scheme in China. There are 3 fundamental laws in the field of data protection in China, which are the cybersecurity law enacted in 2017, and the personal information protection law, and the data security law enacted in 2021. And in the past year, 2022, supporting implementation rules and national standards related to these 3 fundamental laws have also been gradually introduced. As these legislative developments gradually clarify data protection requirements, companies in all industries need to take action to strengthen their data compliance. And data compliance, of course, covers a wide range of topics. So today I will mainly talk about the key topic in data compliance for multinational companies, that is the cross-border data transfer. And to start this topic, let's briefly clarify the typical scenarios of cross-border data transfer. For multinational companies, the most common cross-border data transfer is the first scenario on the left. That is, the data is generated or collected in China, and the relevant data is directly stored outside of China or transferred from China to overseas. This situation is very common because for many multinational companies, it is the overseas headquarters which sets up IT structure with servers located overseas, and then data generated in China is directly stored on overseas servers. But it is also worth noting that in the second scenario on the right, cross-border data transfer also takes place. In this scenario, data is generated or collected in China and even stored on servers in China. But overseas entities can access to the data stored in China. This also constitutes cross-border data transfer under the Chinese data law. So we recommend that companies also check whether there is such a cross-border data transfer taking place. And if the answer is yes, then you also need to pay attention to the compliance requirements for cross-border data transfer. And under the Chinese legal context, there are many categories of data, including important data, core data, personal information data, and so on. So considering that the personal information is a type of data that most companies will process. So today I'd like to take personal information as an example to talk about the main requirements for cross-border data transfer. Next page, please. So in summary, the compliant cross-border data transfer requires company to mainly comply with these three requirements, including you have to send a prior separate notification to the involved data subjects and obtain their separate consent and fulfill one of the three administrative requirements. And next, I will talk about the legislative developments in the three administrative requirements. Next slide, please. The first administrative requirements is to pass a security assessment organized by the Cybersecurity Administration of China. In short, we call it CAC. This requirement is the strictest of the three requirements because it is subject to approval of the CAC, but this is only a mandatory requirement for certain data operators. And you can see below, this requirement only applies to two types of data operators. The first type is called critical information infrastructure operator. Usually they are in some important industries, such as energy, transport, finance, etc. And the second type is the companies which process personal information above a certain amount. For example, companies which process personal information of more than 1 million individuals will be required to conduct the security assessment also. So, but as this is only applicable to some special entities, and in my view, more normal companies need to pay attention to the next two requirements that I will talk about. So let's continue to see the next two requirements. Next page, please. The second requirement is to get personal information protection certification by professional institutions. This requirement is applicable to all other normal companies that are not mandated, not required to conduct the security assessments as just discussed already. In the past year, relevant authorities have also issued several rules for the implementation and some national standards, which clearly stipulate the mechanism for cross-border transfer through the certification way. But in my opinion, this approach is still not so practical. The main reason is that the relevant authorities have not yet issued a list of designated institutions for doing such certification. So in contrast, the third administrative requirement that I will discuss the next is more practical. Next page, please. The third requirement is to conclude a contract with the overseas recipient based on a standard contract provided by the CAC. This is also applicable to normal companies and is an alternative to the second requirement we just talked about. Just last week, the CAC has issued the final version of the measures for the standard contract for outbound cross-border transfer of personal information, and it will officially enter into force on June the 1st of this year. This final version includes provisions on the application scope of the standard contract and provide a final template of the standard contract and also some rules regarding prior recordal of the contract with the CAC. The formal implementation of this standard contracts will greatly improve the enforceability of cross-border data transfer compliance measures under the Personal Information Protection Law. And we believe in the near future, local cyberspace authorities will also issue more practical guidance for local companies to implement the execution and the recordal of this kind of standard contracts. So we also recommend that companies pay special attention to your own compliance status and to implement the conclusion of the standard contracts for cross-border data transfer as soon as possible. Okay, that's it from me. Thank you for your attention. Now I'd like to give the stage to Mr. Schultz for the Q&A session.
Okay, thank you very much to all three of you. So you see the names and the contact details here again. Yeah, it was very interesting. It's very impressive. And as you all saw and heard, there are a lot of changes, a lot of content. Not everything could be mentioned now, and we also run over time. So for those who still have time and in the mood for Q&A, we still can answer a few questions. And feel free to stay in. Feel free to ask and raise your question in the chat. To all those three speakers here. We already have one from Jürgen Haas. And the question is, what happens if the grace period expires and adaptation has not been achieved?
I guess that's a question to me. Then actually statutory law applies. First, I am sure that if the structure was not adopted, the next time anything needs to be submitted for registration to the authorities, like, for example, that a member of the board is changed, etc., the authorities will then actively require the company to change their structure. And also, because so far in old joint ventures, lots of decisions must be passed by the board. So let's assume a share transfer is planned, and then they do a board decision. And when they submit this to the authority for registration of the share transfer, the authority will probably refuse to accept the board decision and ask them to follow the PRC Company Law, which will provide for a shareholder decision. So if the companies do not adapt voluntarily within the grace period, they may run into, I would call it, timing problems later, because the authorities will then actively request them to adapt to the new structure, and whatever decisions made by company organs based on the old structure will most probably not be accepted. And that means, for example, if the joint venture is in urgent need of a capital increase, which must be registered with the authorities, when you only submit a board resolution, they will refuse it, and then you first have to do to adapt the structure and provide the documents in line with the PRC Company Law then. So I recommend to really, in quotation marks, clean up the structure before the end of the grace period.
Okay, thank you very much. I see there's no other question at the moment. I will raise my final one, and I think it's also time for, actually the breakfast time is over for most of them. It's a breakfast seminar. But having said, so you can get the presentation afterwards. You will see, as you can see here, the contact details of all of the experts in the presentation, and feel free to come back to all of them with all your questions or concerns you're having. We also recorded this event, so you are not shown on the record, so we will publish it afterwards and also share it with you when you wanna go back and when you have certain issues. So my question is what I think it's very simple, is it was just mentioned that the severance payments of the employee will be calculated based on the employee's month salary. Does it refer to the base salary or of the employee? Sorry.
Yeah, okay. I think that's a question for me. I would like to answer this question. So the monthly salary of the employee for calculating severance payment refer to the average monthly salary of employees in the past 12 months before the termination of contract. So it does not mean base salary. So how to calculate such average monthly salary of employee? Actually, it's calculated based on all the base salary, bonus, allowance, and benefits, which has been paid to the employee in cash in the past 12 months before the termination. For example, if the company paid annual bonus or the 13th monthly salary to the employee during the period of past 12 months, then such annual bonus and the 13th monthly salary should be included when calculating such average monthly salary when calculating the severance payment for the employee. Thank you.
Okay, then thank you very much, and thank you very much again for to all the three experts here, to Dr. Glueck, to Ms. Yu and Ms. Tang. So having said, it was very, very interesting and impressive. Thank you very much to CMS, our member, that they provided possibility for this very interesting webinar, and also thank to you participants that you stayed in even over time. Please feel free to follow us as the CNBW. I shared the possibilities with you earlier on, and I would like to mention that there is our next business talk on the 4th of March. It will be in German, and Ms. Corinne Abele from the JTAI will discuss with Mr. Lazar on the Chinese draft law on the social credit system. I think also something interesting and probably quite important for the future. Okay, then we're stopping here, and thanks to all of you again. Bye-bye.
Thank you. Bye-bye.
Thank you. Bye.